Liza Lovdahl-Gormsen, Dirk Auer, Tom Smith. Very warm welcome, and thank you very much for agreeing to discuss the Digital Markets Competition and Consumers Bill within the Digital Markets Research Hub. It's a very hot issue. The bill is now in the Parliament in the third reading. Both houses are considering it. And I propose we start this discussion with just reminding to those of us who are more focused on the DMA than on the UK, on its UK equivalent, about the main components of the bill. So Dirk, how about you starting with the designation?
Yeah, absolutely. So the firms that can be designated under the bill are firms that have digital activities in the UK, and more importantly, they need to meet two conditions, which is the first, to have substantial and entrenched market power, and the second, a position of strategic significance. I think the entrenched market power is probably the biggest difference between the DMCC and the DMA. The DMA rather explicitly decided to reject market power as a condition, whereas the DMCC uses this condition from competition, that's inherited from competition law, and adds it to the designation procedure. So that's a very important distinction. It's at the margin, I would say the DMCC is less focused on size and more on sort of traditional questions of, well, what's your market power? What's the difference between the price you're charging and marginal cost? Then when you look at precision of strategic significance, it becomes much closer to the DMA, where you still have these turnover thresholds that are trying to capture essentially, and my co-panelists may disagree, but I guess whether you could almost say in layman's terms, well, is this sort of a really big and significant digital platform?
Thank you very much, Dirk. Liza, the next chapters deal with conduct requirements and pro-competition interventions. Can you highlight to us the main elements of these provisions of the bill?
Yes, thank you very much, Oles, and thank you very much for the invitation here today to participate in this webinar. So Chapter 3 of the DMCC bill is on conduct requirements. And well, you have some, in the DMA, they call it obligations. In the DMCC, they call it conduct requirements, but it's kind of similar in a way, in that you see in the DMA Article 5 and 6, you have obligations, and you see here in the DMCC bill in Chapter 3, which is provisions 19 onwards, you then have the conduct requirements. And I'm sitting here with the bill, which is, by the way, enormous compared to the DMA, enormous. So here we have a, first of all, how they can, there's some procedural rules in the beginning of Chapter 3 on how the DMU can impose those conduct requirements. And then the real interesting part, I would probably think, is what this bill does is it says what they cannot do in a way, and they're also saying what they can do. So they are both what is not permitted as well as what is permitted. So very much, they might use different words, but very much the same as you have in the DMA, such as, well, you're not really allowed to do self-preferencing, you're not really allowed to log in customers, usual things, I would say. So what I do think is important is that it says here that, I mean, it's funny how the bill talks about the CMA throughout the bill rather than the DMU. We know, of course, that the DMU is a unit sitting within the CMA structure, but it's quite interesting how this bill talks about the CMA throughout, not so much the digital markets unit, the DMU, but okay, I'm sure Tom or somebody much wiser than me has an explanation for that. But it says that they're only allowed to impose conduct requirements on designated undertakings, obviously. And Dirk has just talked about how you're there. But then it says here that for that purpose, it's one or more of the following objectives, such as the fair dealing objective, open choice objective, and trust and transparency objective. So therefore, it's within the light of that. And I don't think that the DMA is as explicit on that as this bill is. But it's fairly descriptive, so I'm not going to go through all of that. Your students and who else is listening to that can read that all for themselves. But what's interesting is that when you are designated and according to this bill, the CMA, which I think in reality is the DMU, has then imposed those conduct requirements on the designated undertaking, then those can be revoked at some point. And that means that you can, a little bit like you can de-designate a specific digital activity, you can also revoke conduct requirements. And if you then choose to do so, if the CMA chooses to do so, then they need to have a public consultation on that, which seems a little bit, if you make an analogy to a commitment decisions, where if you impose commitment on an undertaking outside this regime altogether, I mean, now we are back in antitrust and enforcement, that you then also send those commitments out to the market in a way by saying, well, those commitments has been suggested. What do you think about that? Does that make any sense? And here again, you have a public consultation on conduct requirements. So I think that's quite, if you want to draw an analogy to that. But in a way, if for those who really want to understand this, Article 20 is the one that talks about what they can and cannot do, and I'm not going to go through that, but interesting about the public consultation. Anyway, back to you, Oles.
Thank you, Lisa. And maybe for pro-competition, what is the relationship between conduct requirements and pro-competition intervention? Because I remember during the discussions, there was kind of the idea that pro-competitive, as it were before, interventions were somehow a continuation of conduct requirements, whereas in the current version of the bill, it looks that they are separate autonomous parts. More, the first one is more focused on fairness, another one more on contestability, or is it too proactive interpretation of the bill?
Yeah, I mean, we have the PCIs, as they call them. And I'll probably allow my fellow panelists to talk about that more than me, because I've already spoken quite a lot, but also because my understanding is that it's, you know, a little bit like you have competition. I mean, if you go over to enforcement, I mean, this is, of course, sorry, I will answer your question, but it's just to go a step back, that this is supposed to be an ex-ante regime. This is supposed to be regulation rather than ex-post antitrust enforcement. And what we always have had in the UK is something called market studies. So if there were certain elements of a market where you are not, you know, you're not quite clear what was going on, the CMA always had the power to start a market investigation where they then look into whether there is any issues in a specific market. And then if there is, then they can do what I call the second stage, is where they can do where they can then intervene in that market, and then they can impose remedies, both structural and behavioral. You saw structural remedies in the London airport thing, and then you see behavioral remedies. And it's not always following a market study that you end up going into imposing remedies or do go to the second stage at all. We saw that in the Google and Facebook, the digital advertising market study, where they didn't go any further. But if I want to bring it back to the PCRs, I think it's akin to that a bit. But I will probably allow my fellow panelists to talk more about that.
And we will definitely. Thank you very much, Liza. But before reverting to these issues in more detail, Tom, can you just take this last bit of the part one of the bill and outline to us the main elements of enforcement mechanism?
Yeah, sure. So the enforcement mechanisms have been really quite carefully thought out. They've got the existing regime under the Enterprise Act and the Competition Act. And what you can see they've done is they've gone and looked at that and gone, well, how could we make this better for the digital age? They're going to be regulating mostly American-based companies. So when they're sending requests for information, there's not much point in the regime if they can't get data that's held abroad. So they've actually made that much more explicit than is under the Enterprise Act and the Competition Act. The CMA, by the way, recently lost in court when BMW refused to supply documents that were held in Germany. So they don't want that embarrassing result to happen again for the new regime. So they've thought about that very hard. It has all the normal stuff you would expect in a regulatory regime, 10% of worldwide turnover fines, which seems to, for no reason I can figure out, seems to be the standard across the world nowadays. Not that many people are ever fined 10%, but anyway, that's another point. You have dawn raids. Importantly, for this regime, you have the ability for the CMA to force SMS firms to conduct tests and research and demonstrations. Now, that's always been a bit of a grey area under the Enterprise Act, which is presumably why they've made it explicit here. And of course, one of the main tenets of the regime is that they're going to be testing remedies, they're going to be revising them over time. They want to force the SMS firms to conduct A/B testing, for example, to see which type of remedy is more successful. And of course, if you can't make the SMS firm conduct the tests, then that's not going to work. So they've written that explicitly. And importantly, they're making individuals within the SMS firms responsible for things. This is a general theme actually in regulatory regimes. If you really want to get the attention of a big and powerful firm, and remember we're talking about 4 or 5 of the most powerful firms in history now in this regime. If you want to get their attention, then you want to make senior managers personally responsible for things. So that for an RFI, for an information request, the firm has to nominate a senior manager who is responsible for compliance, who can be personally fined, for failing to respond. That's quite bold, isn't it? But they obviously think it's necessary in order to get the firm's attention. So that's the enforcement mechanisms. But just to go back on why the bill talks about the CMA rather than the DMU. I think basically it's probably just a practical point, actually. The DMU is not a legal entity. If you wanted to make it all apply to the DMU, you then have to set up a new regulator, which comes with all sorts of admin and appointments and etc. and cost for that matter. Far better, I think, to write it as the CMA, and then the CMA can organise itself as it sees fit. I think that makes a lot more sense. And just the other point we discussed about, sorry, I'm monopolising the conversation, but the difference between the conduct requirements and the pro-competitive interventions. When I was at the CMA working on the Digital Markets Task Force, we always imagined the conduct requirements as being measures that would mitigate market power, and the PCIs being more one-off, big bang interventions that would really address the source of the market power and reset markets. And I think that distinction just about holds, although I think it's probably softened over time. It's not quite how it's framed in the bill, as you rightly said, Alice.
Thank you very much. And I'm sure a curious mind has already identified probably a dozen of really interesting topics for conversation, and we'll do our best to address most of them. Because we didn't have an opportunity to discuss the bill, it was never presented to the public in contrast to the DMA, where public were facing much more concise, much more harmonious bill. Liza, you wanted to say?
Yeah, I just wanted to come in on Tom's point, which is a very important point he made about holding individuals responsible. And this is, of course, a typical regulatory tool, unlike an enforcement tool, because if you see the sector regulators in the UK, for example, the Ofcom and the FCA and all of those, at least FCA, they had the senior management regime, where we are holding, boards responsible, individual responsible. So in a way, what Tom has just explained about holding individual responsible is a very normal thing to do in regulatory regimes, and something you do see in the regulators, the sector regulators in the UK that have competition powers, but it's not really even linked to the competition powers. It is just that it is a normal thing to hold individuals responsible, and Tom said that's kind of a new and a big thing, and he's absolutely right. It is a very new and a big thing for the competition world, but for those of us who lives in the regulated world, that is quite a normal thing to hold individual responsible. Sorry, I just wanted to.
Thank you very much, Liza. Dirk, let me pass the floor to you if you have some preliminary reflection on any of these things which we discussed last few minutes.
No,
so let us move then. Let us move to the issue. You all three of you have contributed to the Parliament, the oral witnesses in oral hearings. So you have provided your evidence, and you probably sense what the public, what the government, what the Parliament want for it. So what would be the objectives before looking at the juristic peculiarities of the bill? And there are many. Let us just try to identify what is the final objective, if there is something of this kind. And I propose we start this round with Liza.
All right, thank you very much. I mean, they haven't really set out like this is the set of objectives, this is what we're trying to achieve in the beginning of the bill. But I think it's probably to control market power. I mean, one has to be careful what one says, because one does not want to go into the thing as big as bad, but at some point, some companies are getting quite powerful, and they can do certain things, and because of their sheer size, they have a certain ability to foreclose. So I think a main objective is to create fairness in the market, create transparency in the market, and to somehow control the amount of power that's being wielded around. But that's just my take on it, and I'm sure my fellow panelists they will have something to add to this.
So Tom, how do you decode this objective?
Yeah, so I would say that there are certain firms, a small handful of firms, that have reached a position where they hold gatekeeping power over the modern economy. Now, these are great firms with great products who do great things, so no one's trying to stop them innovating or anything like that. But they do act as quasi-regulators over their ecosystem. You know, Apple can kill your app, and if you don't have an app, you barely exist in the modern economy. Google Search can put your website onto the second page of results, and when was the last time you clicked onto the second page of results? It's not any time recently, in my case. So they act as gatekeepers, and they're not evil. They're great companies. But at some point, I would say the democratic process has to step in and actually make sure these ecosystems are operating for the good of society and enabling innovation to flourish, so that tomorrow's Google can get off the ground. So in terms of what it's trying to achieve, I would say that I may possibly make a distinction between the short term and the long term. In the short term, there's a range of artificial barriers that exist in these ecosystems that are just very obviously going to be better if they're removed. When Apple bans alternative app stores, that is just shielding itself from competition. So a rule that got rid of that artificial restriction would very obviously benefit lots of people and the economy more generally. So there's lots of concrete steps that the DMU can take on day one that will improve the world. In the longer term, of course, then it becomes fuzzier and more difficult to measure. Economists can measure anything, of course, but more difficult to measure. What does success look like? Hopefully, the barriers are reduced so that new firms can grow. Payments firms can compete with Apple Pay, or third-party sellers on Amazon get a fair crack of things without having to pay Amazon's advertising fees, etc. So it'll be difficult to measure, but hopefully the the digital economy will look better in 5 to 10 years' time.
Thank you, Tom. Dirk, how do you read the objectives of explicit, implicit? Are they realistic? Are they necessary? And all this?
I think the starting point is a dissatisfaction about how these large internet platforms look today. So I think proponents of the bill would say, we have these very large platforms, but we would like to see more competition at the edge of these platforms. And when I say competition, I mean quite explicitly, and I think regulators mean quite explicitly, not just competition for the market at the edge of these platforms, but actually a diversity of firms operating at the edge. So you take Apple's Play Store, Apple's App Store, you'd want more payment providers at the edge of that platform, and you can sort of repeat that same pattern for different online platforms. Now, I think that's a dissatisfaction, and I think the bill aims to change that and make it easier for firms to exist at the edge of online platforms. Whether that will work or whether it will not work is really going to be a question of, well, why for the moment does that not seem to be happening? And I assume that at least probably my co-panelists would say, well, because the large online platforms have gatekeeping power and they're preventing competition from sort of existing at the edge. And I think my position would be more, well, maybe it's also because consumers value this sort of integration between the core platform and the edge services. And there is some value to that. And I guess that's sort of where debates between both sides fall. But I could be wrong.
I know there is a temptation to engage in this normative, but we have limited time. So I propose, we know each other's position, and the position are very well articulated. Let us move to the more technical details. And in this round, I will probably ask you, Tom, to start. Namely, we look at designation requirements. So who are the gatekeepers, the undertakings with strategic market status?
Yeah, so the designation requirements. So this is the main difference between the DMU and the DMA. The DMU is much more bespoke. The DMU can't do anything at all unless it can prove its case one by one company by company, one activity by activity. So the DMU will be designating specific activities within firms as having SMS status. So I would expect Google Search, for example, or Apple App Store. Google will probably have several designations, something like that. The designation lasts for 5 years. Now, one debating point has been whether it's even possible for the DMU to make these decisions looking forward 5 years in the future. It is a difficult one. The SMS test is based on entrenched market power, and if it's entrenched, then it's not going to change. So if you can't prove it's entrenched, then you shouldn't be doing it for 5 years, and it doesn't satisfy the test. I think we'll have to see how that goes. I mean, if you made it for, I've heard people arguing for 2 or 3 year periods. My own view is that that's too short, that the whole regime will be about the designations and nothing else. No one will get onto the substance of the issues, and that can't be anyone's preferred outcome, really. So for me, 5 years works. And then the CMA will be obviously writing the conduct requirements separately for each activity one by one, which gives it a lot more scope for being inventive than the DMA, and for being flexible as time goes on.
Thank you very much, Tom. Dirk, how do you evaluate the very mechanism of designation and more general and this entrenched market power elements of Section 5 more specifically?
How would I compare it to the DMA? I think the big distinction is the market power requirement. That's the main difference. I think under the DMA, things seem to be much more predictable, and under the DMCC, the question mark is, well, how courts then look at the market power requirement. You could imagine an interpretation that's basically in line with competition law, and I think that would significantly alter the way the DMCC plays out. But I don't read anything in the bill to suggest that that when it says market power, that market power is necessarily to be interpreted the way it is under competition law. So I think that's uncertainty, and I'm not sure that at this stage it's resolved.
Liza, how do you understand the main problems with this, or how do you find them? Do you find this more elegant, more discretionary for the CMA to designate on much more bespoke basis than in comparison to the DMA? And again, why do we need this 5-year forward-looking? Can you evaluate digital markets with 5-year kind of forward-looking? Did anybody know about ChatGPT, all this stuff? Is it realistic? And is it necessary to improve the entrenched status?
Well, I think the 5 years is a bit arbitrary. Having said that, though, they can say if whatever they're asking them to do, they're imposing a conduct requirement for 5 years. If they stop doing what they're doing and things have sorted themselves out in the market, then it doesn't have to last for 5 years, though. But so that's an important thing. The second thing I would mention is in regulation, usually when you regulate in a market, it's an ongoing process. You don't have an end or a beginning. It's kind of a long, continuous thing that's going on. But I do think that one has to be careful to talk about a system that hasn't come into force yet, because we're still waiting for royal assent. But I would probably say that it appears, at least in theory, that the UK system, the more bespoke system, is a better model than the broad brush DMA, to be honest. For the very reason is it totally acknowledges that these firms have vastly different business models and are operating in vastly different markets and just do very different things. And therefore, how can one, like the DMA, have this broad brush? So I do think that having a more bespoke system is probably a good thing, because it acknowledges, the reality of the world, really.
Thank you very much, Liza. After designation, the next important question is conduct requirements. We already know the main rationale of it, but maybe we can discuss also the contravening benefits exemption, the formulas in which these mandatory exemptions are introduced. Is it beneficial? Is it necessary? Is it, again, enforceable? And all the cascade of how the obligations, the conduct requirements themselves are tailored using this proxy of kind of the obligations don't exist. They are aiming, the CMA receives the discretion to design obligations based on these imperatives which are listed in section 20, I believe. Dirk, let's start with you. What are your thoughts on this part?
I think probably the best way to understand the DMCC is actually to situate it compared to one competition law and compared to the DMA. So you can imagine competition law being, let's take the broadest possible obligation, very short amount of text, and let's let courts figure out what that means. You look at the other end of the spectrum, the DMA it's the opposite. It's like, let's write down very, very specific obligations and actually let's apply them to all the firms that are regulated. The DMCC sort of falls in between that, where you have this sort of intermediate system, which is once a firm is designated, there is a list of requirements that the CMA can pick from, and will figure out which of those are relevant to the regulated firm. So it's sort of, I think of it as a hybrid between competition law and the DMA. The question then is, well, competition law, the idea is that judicial review is going to essentially flesh out what the regulation means. Under the DMA, judicial review is going to, I think, play a much smaller role. And actually, in the DMA, what's going to play a bigger role is just the commission saying, maybe there are many obligations that apply to that gatekeeper, but in fact, we're going to focus our investigations on only a couple of them. So, somewhere between the two here, I don't think the role for judicial review is as big as under competition law, and I think it is more flexible than the DMA.
Thank you, Dirk. Liza, how do you see the conduct requirements, the formulas which are present in the relevant chapter?
Well, I don't have much to add to what Dirk had already said, but I would like to pick up on one thing he said on judicial review, that I agree that it's probably going to play a much bigger role here, judicial review, because there's been an ongoing discussion, you will all be aware, an ongoing discussion throughout the discussion of this bill, the draft bill, whether one should allow designated undertakings to get a full merits review or merely just judicial review. And just to remind anybody that judicial review is on appeal. You don't go into the substance of the case, but you look at whether the authority here, the CMA, whether there's any procedural irregularities or any procedural errors. And if there is, the court can then remit that back to the CMA, whereas when you have a full merits review, the court can put their decision instead of the regulator's decision. That's just a very simplistic distinction. But it was a very, very big debate on whether this bill should have judicial review only, full merits review, or something of a hybrid in between, which was what I call JR plus, right? And JR plus is where you basically allow the court to look at the substance for a specific period of time, and then you look at whether whether the new system has embedded itself, and whether the court has kind of drawn the boundaries around what one can do and what one cannot do, and then you review whether that has worked. And if it's now working and we all know what this system is about, you can then go to JR, back to judicial review. That was a model that Ofcom, one of the other regulators in the UK, has used. But they decided that in this bill, it was going to be judicial review only, JR only. And I don't, to be honest, think that is a good idea. I know I'm one of the few people who think that, and people are quite outrageous when I'm saying that, because they say if you give a full merits review to these designated undertakings, they would use it as a strategic advantage to just start litigating endlessly. And then that defeats the purpose of this, which was to try to get some quick measures around this, rather than ex post enforcement, which takes a great number of years.
Yeah, thank you very much for this point, and we will revert to. I think Dirk is another person who shares this view, endorses this view, and I think Tom has published recently, co-authored a paper against this position. So I propose we will dedicate a separate kind of block of questions to this very sensitive and probably one of the most topical issues. Thank you very much for noticing this, the importance of this element. Tom, finally to you about conduct requirements.
I hope we reach a place where, I mean, the CMA is going to find itself able to flex and revise the conduct requirements as time goes on, which is really tremendously useful. The European Commission, of course, won't be able to do that in quite the same way. I hope we can reach a point where the two authorities are working together quite seamlessly, and actually, the European Commission's suggesting amendments to the DMU that they can actually take forward. I mean, these are global issues, of course. The two regimes, vary, and if the two authorities can actually use them to their advantage, that will make a more successful regime. But I mean, so Section 20, as everyone said, sets out the conduct requirements. Really, they're very broad. I don't see any real kind of hindrance there to the DMU doing its job.
Thank you very much. Liza, contravening benefits exemptions, in other words, in a colloquial sense, efficiency defense, yeah? There are so many, there are so many arguments against these provisions being introduced during the DMA discussions. And people were saying that if you can find efficiency defense for criminal offenses of cartels, it would be so easy, so much easier to find the contravening benefits exemption for much more mundane, much more trivial business routine, etc. Many other arguments have been raised in support and against this mechanism in ex ante modality of quasi-competition rules. What is your view on the rationale and maybe on legal mechanics as well?
Well, let me take a step back and make an analogy to competition law, where we all know that in Article 101, you have an exemption in Article 101(3) if you fulfill the requirements in there. You also, under Article 102, have objective justifications. So insofar you have an objective justification for your behavior, you're kind of let off the hook. I mean, that's very simplistic, but you know where I'm getting at here. The reason why I'm making this analogy is because what they're trying to do here is get some sort of sense that if the undertaking in question has some sort of excuse or you know, then they can be exempt. But a little bit like objective justifications under 102 or Chapter 2 in the UK, it is very, very, very difficult, right? And the same with Article 101(3, very, very difficult. So only time will tell whether these are actual, I mean, whether anybody is getting away with this. I am not gonna, you know, I will eat my head because I'm probably gonna be wrong on this. But if I look into my crystal ball, I'm not quite sure how that's gonna fly. I mean, I'm just not quite sure how that's at all gonna work. But that's just my humble opinion, and I'm sure both Tom and Dirk will have something to add.
And if your crystal ball is not clear after publishing a monograph, I think some time ago on 102, if I remember correctly, I still have it in my library. So it's really, really challenging provision. So let us try to unravel it together. And maybe Tom.
Yes, I think you have to accept that any regulatory regime needs to have some kind of exemption clause so that you don't end up punishing conduct that is actually in the round not harmful. I would question whether you need it on the face of the bill at all. When the CMA comes to draft the conduct requirements, it will be conducting pretty careful trade-offs between hampering innovation and enabling innovation. And you would expect it to write bespoke exemption type clauses into really every rule that it writes, because that's the nature of the exercise that we're doing. So really the only reason I think to put it in the face of the bill is because the SMS firms will argue that something like that is needed. So it would have been there anyway. I think it's pointless in the bill, but there you go, it's there. And
the fact that they are mandatory, and when we talk about exemptions of 113, we also have to consider block exemptions, which are essentially exemptions. It doesn't change the situation much.
Yeah, I suppose the block exemption equivalent will be the conduct requirements. They'll say, you know, if you do this, actually, it's going to be fine. You'd expect them even to write in safe harbors and even pre-agreed things. You know, we recognize you're going to want to do this. We think that's fine. Yeah, I mean, there's going to be a whole, you know, there's a lot of pages left to be written, still to be written in this regime.
All right, thank you very much, Tom. Dirk, how do you assess this mechanism?
I think it's important to consider the question that regulation could be harming a feature of these platforms, and to have some security there, some option for regulators to, or for firms to argue, well, look, this is a mistake. Now, to some extent, I actually agree with Tom. I think at the end of the day, regulators, when they figure out their requirements, they are going to be conducting those trade-offs. As it stands now, the exemption, I think it's not only weak, it will be even weaker than objective justification under Article 102. It's a little bit of a dead letter, because there isn't a very strong judicial review behind. So at the end of the day, if the CMA says, well, look, we've looked, this behavior harms consumers, I don't think that the possibility to put forward these countervailing benefits is going to help firms very much. Again, it depends on what side of the debate you are. Lisa's point is well taken, that I think it was Lisa saying, well, we may want, what was it, Tom? We may want expediency here. And so we don't want to have every sort of decision being appealed on full merits. The trade-off, it's a trade-off, right? At the end of the day, it really depends for your appetite for false negatives or false positives.
Indeed, and if you look at pro-competition intervention, which is another chapter of the bill, how do you understand what is? We mentioned this in passing already, but more substantively, what is the relationship in the bill, not in the kind of framework of digital markets task force and the previous discussions? How do you see them? Is there a continuity between the conduct requirements and pro-competition interventions? We don't have efficiency defense in PCIs. What makes these two mechanisms so different, and what's the rationale behind it? Tom, let us start with you this time.
Yeah, so they're just separate tools to choose from, really, in the act, in the bill. As we already said, the original there was an original intent where where an issue needs really quite careful and detailed analysis of the trade-offs, it's going to be better as a PCI. So you can appoint a case team to it. A case team, a large case team, can consider it properly and decide what to do. The more cut and dried things can just be written straight into the conduct requirements. So I would say the conduct requirements are going to be done first. So there is a two-tier. There's nothing that in the bill that says this, but in reality, the conduct requirements are going to be done first. The SMS designations will be done in parallel with the conduct requirements, and then a little bit after that, you should expect to start seeing PCIs. I think PCIs are going to be, my prediction is that they'll be narrower than market investigations have been. If you look at market investigations, they look at the whole retail banking market or the investment consultant market or the energy market. I don't think it'll be anything of that sort. I think it'll be much more targeted. So whilst the legal test is technically the same as the market investigations, I think it'll be a quite different process.
And how do you see this, Dirk?
I mostly agree with Tom. Like I think, yeah, from not normatively, just objectively, I think that's how it will work. I'll be curious to see what the CMA does with this. Yeah.
Liza, what is your view on these two autonomous regimes? Do we need them, or is it something which is just specificity, or there is some broader rationale behind this?
Well, I'm not going to go as far as say it's a nice add-on, but nothing more than that. But it does appear to me that the conduct requirements is first priority for sure. And it's only if they need to buy themselves a bit more time and look a bit broader, although I agree with Tom, narrower than the market study and the market interventions. But it's I would also be surprised if we suddenly see a lot of PCIs, floating around. That may come further down the line when the system has developed and matured a bit, and they have imposed enough conduct requirements, and they need to look a bit broader, because of course they have allowed themselves this tool exactly because the conduct requirements are very specific to the individual firms. And therefore, if they want to then go a bit beyond that, then they have this second tool of the pro-competitive interventions. Yeah.
Okay, now it's much clearer to me after your references to and explanations. Let us move to the issues of kind of new enforcement culture, cooperation, communication, regulatory dialogue. Obviously, it's a new era of enforcement. So Dirk, how do you envisage, how do you think we will function in the following years once the bill becomes an act?
I don't know that is actually all that new. Like regulators have, if you look at the history of European competition, or it's a history of the regulator talking with the firm under investigation and third parties of all sorts. Like that's how these things are done. I don't think, I may be wrong, I don't think that there's a fundamental shift here in how that's done. And the pros and cons of this approach are well established under European competition law. So I don't think it's sort of the seismic shift you might think it is. There are always risks if you're the regulator, because the people you're cooperating with or you're asking questions to, they may have incentives that are not aligned with yours as a regulator. That's the risk. But
thanks very much. Liza, do you anticipate some significant shift in this kind of communication dialogue, multi-log between the enforcer and the undertakings with strategic market status?
Well, let's see if there will be a regulatory dialogue at all. But regulators, only because I work at the FCA, which is of course a regulator of financial services markets, is that you have an ongoing dialogue with the companies you regulate all the time. So as Dirk said before, there's nothing new in this. I mean, in a regulatory system, you have a dialogue with the firms that you regulate all the time on an ongoing basis. Well, you also have a dialogue in competition enforcement cases. I mean, Tom, he can talk about that. He worked for the CMA, but I mean, there was also a dialogue there. I mean, it's not like the CMA works in isolation and come up with all of these things and never see the parties. That's the same in merger cases. And then one day they just slam down a statement of objections. Of course, there is an ongoing conversation, but the regulatory dialogue is, I think, very important here. In this system, because the point is, if we want to make this work, there will always be an information asymmetry between, like it is in enforcement, between the information the company has and the CMA and the DMU, which needs to impose these conduct requirements. And therefore you have a dialogue, because you will suggest something and the company will come forward and they will say what they have to say about their business. And obviously the regulator can see very quickly if they're just whining and you know, trying to be obstructive, or they're actually bringing something to the business. So let me make a little bit, I love analogy. So let me make a bit of an analogy to phase 2 of the merger regime in the UK, where a case where the regulator or the enforcer has significant concern about an acquisition, and it goes into phase 2. At that point in time, they speak to the parties and they usually invite them in. So there will be a panel at the CMA inviting the one at a time, the targeted company and the acquiring company. And then you go before panel. And what they're really trying to do with the questions they're asking is to understand the business and to understand the market. I mean, it's genuine. They really genuinely want to try to understand what's going on before they make up their mind in a phase 2. And similar here with regulatory dialogue, one would hope that they're really trying to understand what is going on here, and that the designated undertakings are really trying not just to prolong and obstruct, but actually trying to engage in this regulatory dialogue.
Thank you very much, Liza. Tom, how do you see it? Do you agree with previous two speakers, or you are more, you expect more?
Yeah, so I mean, so I was at the CMA for 7 years, and I did each of the different tools. So a competition investigation, I don't think anyone would call that as a dialogue. I think that's an adversarial process all the way through, with a merits review at the end. Importantly, a merits review basically kills any chance of having a participatory dialogue. I would say. In mergers and markets cases, much more collaborative, where the parties are incentivized, and really this is all about incentives, and this is what the regime is trying to set up in the right way. The parties are incentivized to try to persuade the CMA of the right outcome in the merger or the market investigation, and that's a much more successful way to understand the market properly when it's more participatory. In the new regime, they are certainly aiming for a more participatory setup. The ability to refine remedies over time, of course, helps that. And I think the incentives are being set up in the right way, but it does depend on the judicial review appeal. I think the merits will be able to kill it.
and this leads us perfectly. I'm mindful of shortage of time, but let us revert or continue on the issue of judicial review. Lisa, you have highlighted quite a significant elements already to us. Let us continue, and maybe we can reflect on other which have not been mentioned yet.
Well, the reason, as I said to you before, why I would argue for time-limited full marriage review until the system has embedded itself. And I know that people will throw tomatoes at me when I say this, but I'm going to say it because I do think it is extremely important in a new regime. CMA has never been a regulator before. They're going from being an enforcement authority to also be a regulator. This is a new system where they're designating undertakings and imposing conduct requirements. And that is a new system. And I think it would only be reasonable that the court has a say in this. And can I just highlight here that I am not a lawyer in private practice, so I do not represent any of these companies. So I don't have a skin in the game. I'm not saying this because I'm being paid to say this, or these are my clients. I don't have a skin in the game. I just think that is reasonable. The UK is still a member of the European Human Rights Convention, right? And that applies to companies as well. So I do think that they will face quite a lot of criticism when they are imposing a brand new system without allowing full marriage review. And I'm not saying this has to be forever. I'm saying one could review this after 7 to 10 years or whatever. I mean, I'm just picking up a number here. But after you can see that the system has embedded itself and saying, okay, now we know where we're going with this. And we're all clear on what this is. Right, now is to just review from now onwards.
Thank you very much, Lisa. Tom.
I disagree respectfully with Lisa, which is where the fun comes. Yes, JR, I would say, is the tried and tested, well-established standard for regulatory regimes in the UK. In fact, the direction of travel has been away from merits and towards JR in recent years. In fact, the DFCC bill itself changes the interim measures standard under the competition regime from merits to JR. I think it's the right approach where you have an expert regulator. Giving merits review essentially gives the SMS firms 2 bites of the cherry. It changes the dynamic during the administrative phase. They are incentivized to keep information back, save it for the appeal, where they'll always think they'll get a better shot, because basically courts decide on the case at hand and do not have a wider remit to consider digital policy goals. So when the DMU is trying to achieve digital policy goals, it is more likely to come up with decisions that try to achieve those. Just on the human rights point, I think it's an interesting one, isn't it? And that's one of the reasons why we have inquiry panels for market investigations, for example, to try and satisfy Article 6 of the ECHR. I would say that the German gatekeeper regime is already in place, the Section 19A regime, and my understanding of that is that appeals on that to the top court are only on points of law, so arguably more akin to a JR standard than a merits standard. So they've obviously taken the view that that's compliant with human rights law. Also, market investigations are subject only to JR. Now, if you're worried about DMU decisions being robust and good enough, I think the best way forward there is actually to make the decision-making process within the DMU more robust and trustworthy. For example, making sure they disclose the full underlying data to the interested parties so they can challenge it. Basically making a much better process than the current phase 2 mergers, for example, where the parties frequently complain they haven't seen the underlying data. So if you made the actual administrative phase more robust, then you wouldn't need to worry about the parties having 2 bites of the cherry, which is pretty inefficient all the way around.
Thank you very much, Tom. Dirk.
From my point of view, it may seem obvious, but I'd rather have a different institution writing the rules and deciding on cases. And I think that there is a risk in its current form that the DMCC doesn't achieve that, because as we've discussed before, these are relatively broad provisions, broader at least than in the DMA, and absent a strong role for courts. I think it's almost, and I probably accepted that essentially we'll be saying to the CMA, look, these are some broad goalposts. You have very significant power to do what you want, so long as you stay within these very, very broad limits. I think, I've said this before, but what it boils down to then is, what's your appetite for false positives and false negatives? And, essentially, I have an appetite for limiting false positives. I think that that's not the consensus for the moment. There is clearly a big constituency saying the problem with European competition law is that it's not expedient enough for regulators. So from that point of view, I think that what the CMA is doing here, or what the bill does, it solves the expediency problem. I just fear that it comes at the expense of having courts play a sort of a counterbalancing role in writing the rules. And I think that's a significant loss.
Thank you very much, Dick. Does anybody want to reflect very quickly on each other's points on this, if there is something very urgently needed to be commented? If not, the next question, I'm mindful of time again. Is the DMCC a continuation of competition law, or is it something sector specific? Is it an ex ante rule, which is a new start, as we have with the DMA, or is it continuation? And what are the implications, Tom?
It's both, isn't it? I think probably stepping back, once an industry becomes so central to people's lives, it's almost inevitably going to be regulated in the end. So that was always going to go. It has, as Liza already said about the parallels with the FCA type regime, it does have a lot of parallels with a regulatory regime where you have a standing regulator, ongoing relationships, etc. So that's quite different from the competition regime where the authority suddenly arrives in the industry, does something, and then gets out and never looks back. So it's quite a different dynamic there.
And what would be your view, Dirk?
Yeah, I agree. It's sort of it's a mix between continuation and a new regime. I think that some of the things that are in there that are continuation are actually things I would have carried through. I think that the reference to market power is desirable. I think that the idea that you can put forward countervailing benefits is consistent with what we've been doing on the competition law. I don't know how effectual all of that will be. And at the end of the day, if you are to ask me to look in my crystal ball and say, oh, will enforcement under the DMU look more like competition enforcement or more like the DMA enforcement? I think it will end up being quite similar to the DMA. Like there are differences in the bill, but in practice, it's not clear to me that it will make a huge amount of difference on the ground. So I would say more novelty than continuation.
Thank you, Dirk. Liza, how do you assess it?
Yeah, I don't have much to add, but what's interesting is when you then sit down and read the individual provisions of the bill, there's so much from competition law. I mean, the language is just the same. I was just trying to look in my notes, reasonable grounds to suspect. I mean, that's just section 25 on the Competition Act of 98, right? I mean, so constantly you have this wording being transposed from competition law into this. This looks very, very different from FISMA, which is what we is using in financial services market, and the FCA handbook, which is based on principles and stuff like that. It looks very, very different from that. But let's see. I mean, I don't want to be too negative about this bill from the beginning because it has taken a long time. I know a lot of very clever people have thought about this for a very long time, but it is quite interesting how how you have all the very much the same language from competition law into here.
Thank you, Liza. We have 5 minutes, and I wanted to ask you some recommendations to students, but we still have a few questions. So I propose if I mention them, and each of you can pick one to reflect if there is a need. Too many mandatory public consultations. Is it the case that if you have to consult all the time, when do you will be enforcing it? A. Second one, what should be the relationship with the government? If you receive such broad competences, should you coordinate? Should you still look in the microeconomics textbooks in order to identify what's right and what is wrong? And three, quasi-criminal nature of sanctions. Does anybody want to reflect on any of these 3 points? Tom.
Consultations is an interesting one, isn't it? I think I mean, even if it wasn't written in the bill, the courts would write it in anyway through general public law. So you're going to have to consult anyway, and you're not going to make very good decisions if you haven't spoken to anyone that's going to be affected by the decisions. And I think consultations are inevitable. I think there is a mismatch, by the way, between the consultation rights given to the SMS firms and the consultation rights given to the non-SMS firms, who may be just as closely affected by the DMU's decisions. But the non-SMS firms often don't get full rights or full sight of what's going on. They only see a published summary. Who knows what a published summary means, by the way? I mean, is it 1 page or 20? We don't know. So I think there is a mismatch there that should be fixed. But anyway, that's probably a too small a point of detail.
Thank you very much, Tom. Dirk, on any of those points, or to reflect on what Tom said?
Very briefly, just on the relationship between the CMA and the government, I think one big thing that we haven't discussed yesterday is this provision that the Secretary of State could add new requirements. That, we've got limited time, but that is a pretty big thing, and it will create questions of, well, how does then the CMA and the Secretary of State, how do they dialogue, and what will that process look like in practice?
Is it in a new provision? I think something of this kind was always in competition, but I have to double check. Liza.
Just to very quickly pick up on Dirk's last point, it's very interesting to see where there is affirmative procedure and when there is negative procedure. And just for those students that don't know what that is when you have an affirmative procedure, you need to approve the obligation. That means that delegated legislation is laid before Parliament in draft form, and Parliament needs to approve it. Whereas when you have a negative procedure, it's an information obligation in kind, where delegated legislation is signed by the minister and then laid before Parliament, but not for approval, just to inform Parliament this is happening, right? And I mean, there you see that when it comes to kind of turn over things that can change quickly, then it's negative procedure. And when it comes to kind of the conduct, the conditions in their condition, in 5 and 6, condition 1 and 2, then it's affirmative procedure. So it's important to pay attention to what's need approval by Parliament and what does not need approval by Parliament. But that's just to follow up on that point. In relation to you mentioned, Oles, in the beginning about quasi-criminal nature. And that's exactly one of my points with the new regime, with JR versus full marriage review, is when you do have something that's of quasi-criminal procedure, and also the fact is that you can hold individuals responsible, that then, I'm not sure, competition law is of quasi-criminal nature because of the fines imposed, and because, of course, you can have a criminal cartel as well, where you can ask for prison sentences, and here you can hold individual responsible. So I do think that just having the DMA on its own, making those decisions without being not being able to be appealed on full merits appeal, I think it's quasi-criminal. No, I think it's not ideal.
It's always good to end conversation when there are many other things to say rather than other around. We still have few seconds. So let me ask your recommendations for students as a matter of tradition of our series. Tom, let us start with you.
I mean, I find the tech sector endlessly fascinating. Actually, there's things to read every single day. I would recommend to read extremely widely and sign up to lots of the good newsletters that there are about the place, and listen to all the tech podcasts, and become, if you fancy a career in the new DMU regime, you know, it's read.
Thank you, Tom. Dirk.
Yeah, absolutely. I agree with Tom. We actually talked about this before, and he said, "Oh, I enjoy doing these podcasts because I learn." And I think if I had one piece of advice for students, it's find something that you enjoy, because that makes it so easy to learn and to read about. Become obsessed with something that you want to become obsessed about, and then you create a niche.
Thank you, Dirk. Liza.
Yeah, I mean, law students, right? You can go in all sorts of laws, and you can become all sorts of lawyers. But the reason why it's so interesting to become a competition lawyer, and therefore not only be a competition lawyer, but specialized in tech and what we have discussed today, is the real world. These companies are dominating our economy. We're living in a digital economy. We're living in a platform economy. I mean, this is real. I mean, unless you want to be a conveyancing lawyer, where you obviously people are buying and selling houses and need help with that. But I mean, this is real, and it's interesting because there is probably none of your students that are not signed up to either Facebook, Instagram, or WhatsApp, or don't use Amazon, or don't use Google as a search engine, or have Microsoft on their laptop. I mean, this is real, and it's very, very interesting to work. I would say as a technology lawyer, that's the wrong word, but work as a lawyer in tech. It is endlessly fascinating. And it is, I would say, now a little bit of law, a little bit more of economics, and a lot of politics, right? So there is, you know, it's not just law, it's also politics, and it is economics. And it's probably also a bit of philosophy. So I do think it's fascinating, interesting. So I do hope that people are interested in entering or morphing into this area of law.
Liza Lovdahl-Gormsen, Tom Smith, Dirk Auer, many thanks indeed for sharing your fascinating ideas with all of us today.
Thank you very much.
Thank you.